Hey, how you doing today? In today's video, I want to go into to talk about these debt junk buyers. I want to talk about because it seems to me, according to my interaction with people over the internet, they don't quite understand the difference between debt junk buyers and debt collectors. But I want to go into the debt junk buyers and what their role is. So stay tuned. My disclaimer here is that this is not legal advice. This is not financial advice. If you would like legal advice and financial advice, then I suggest you find yourself a competent professional, and by all means, please be advised. What I'm about to say here today is strictly for education and information purposes only. And the views and opinions of me, Raphael Bird, does not reflect any of the views and opinions of any platform that hosts Blind Intelligence. Now, let's talk about this for a minute, about these debt junk buyers like Midland Funding, LV&V, Portfolio Recovery. And there is a plethora of other debt junk buyers that are out there that buys your debt for pennies on the dollar. But a lot of times, they send us letters in the mail, and we don't answer them. Then we get a summons. Or they send it, depending on what your state is, you get what's called a certified letter. Because you signed for it. That means you got it. That means you've been served. You see. So now, what do we do when it gets to that point? You know, and what I'm constantly hearing about what in a lot of these chat rooms, because I do visit Facebook and I look at a lot of the different comments that people are having with dealing with these debt junk buyers. You know, I paid them this, that, whatever the case may be. I'm trying to figure out, you know, when they give out information, they don't give out the full information. You know, that's number one. They don't tell the full story on how it got to the point where you had to pay them. If they wasn't your original creditor, how would it get to that point? And that's something that needs to be really examined. Because LV&V and Midland Fund and all these debt junk buyers, you should not be paying them anything. Because under 15 USC 1692G says validation, and they must cease all communications until they are able to validate the debt. Now let me explain it to you. Now they're going to send you a lot of invoices. Invoices is not validating that debt. They have to have an assignment. They have to have your signature, your wet ink signature on the documentation. And they have to have something showing that they are the buyers of that debt, right? Like a receipt or something of that nature to prove that they own that debt. They're not going to do that. You know why? Because they're debt junk buyers. And debt junk buyers, all they do is when your creditor, the one that you got the loan from, whether it's the bank, whether it's the side loan company, a personal loan company, whatever the case may be, a furniture or whatever, credit card, whomever your creditor is, they picks up, your creditor charges it off. Charge off. What is a charge off in a nutshell? Well, what they do, you have two ledgers, right? You have a pay ledger and a non-pay ledger. They take it out of the pay ledger after 190 days that you hadn't made a payment. When you haven't made a payment on that loan, they put it in a non-pay status after 180 days. Now what happens is that they do what's called a charge off. A charge off ain't nothing but a write off to where they're gonna file a 1099-C, put it on their document, put it on their or 1099-A, they're gonna claim it, and then they're gonna write it off on their taxes. But here's the deal: in that process of them putting it in pay status, you got a company, a third-party debt collection company, that's gonna come and they're gonna pick it up for pennies on the dollar. You gotta understand this. You know what I'm saying? I hear it a lot, and I'm speaking to all of those that review this video, because you have to understand, they have to prove that they own this debt. You go to start paying them, you just create a contract for yourself. Stop contracting with these people. They're not your original creditor. But when you pay them, automatically contract. Contract comes in two forms: express and implied. Your actions can produce a contract. Your words can produce a contract. So you got to understand that. You're producing the contracts. You make one payment, you just made a contract. You admit that you owe them, you made a contract. You have to understand that. You can't keep throwing money at it, because believe me, there's no guarantees that these third-party debt collectors and their attorneys is going to do you right. Because number one, when you get to court, it don't be nothing but the attorneys. They got all these affidavits and stuff and everything. An affidavit can be rebutted in court with an objection. Remember that. And I don't care what attorney out there that tells you that it can't an affidavit, because you have a right to face your accuser. You can't cross-examine an affidavit. You can't. You're there. You're there standing in honor. You have every right. You're bringing me in here. You're proving your case. I have every right to cross-examine. I can't cross-examine an affidavit. So I'm going to object to it automatically. I'm going to object to everything that attorney is saying, because that attorney, let me explain it to you. The attorney don't have first or second-hand knowledge of anything. All they have is paperwork. They have paperwork. The judge is going to ask you, do you owe this debt? No. Block and I'm denying everything. Because it's what you can prove. It's not what. No, I don't owe that. Did I sign that document? No, I didn't sign it. If it's a copy, I'm not allowing you to bring any copies in the courtroom and my signature, my so-called signature on it, because you can go on to GIMP or Photoshop and you can forge a signature. So don't get bamboozled. Do not get bamboozled by these third-party debt collectors, and learn how to object. You know what I'm saying? Learn how to object. You ain't got to go in with fancy jargon, but learn how to object to all this, to anything that attorney is saying, because they got to prove their case. They brought you in there. Don't allow them to, you know what I'm saying? The judge is going to ask you, this document, did you sign it? No, I didn't sign it. I didn't sign that document. That looks like a forgery. I'm not admitting to anything. I'm not admitting, I'm not denying. So if you're under penalties of perjury, how is you perjuring yourself? You didn't admit and you didn't deny. They say that looks like a forgery. Where's my original signature? You have a right. So but I just wanted to come on here because I wanted to get this stuff cleared up with these third party debt collectors, because those third party debt collectors are real strategical in their acts, because a lot of times people don't know what the law is. You don't know what the law is. You don't know what your rights are, and they know it. They know it based on how you answer them, based on how you moving. They know you don't know, so they're gonna come in with all these different types of fancy jargon and all this kind of stuff, and they're gonna try to sway the judge to be in their favor and all of that. And you gotta have some firepower. You gotta have some firepower, and your firepower, ladies and gentlemen, is consumer law. Learn the consumer law. You need to be learning the Fair Debt Collection Practices Act, the Fair Credit Reporting Act, and you need to be learning the Truth in Lending. And I think it's another one is called the Fair Credit Fair Credit Rights Consumer Act. I can't remember, but it's a bunch of them. But those three right there, the main three, that's your firepower. That's your firepower. Truth in lending is when you're facing with the lender, like you're trying to get a house, you're trying to get a mortgage, you're trying to get a loan for a car. Your Fair Debt Collection Practices Act is when the debt collector is trying to come after you. There's rights that you have that they don't. They don't have no rights. Fair Credit Reporting Act is when you got the consumer agencies. You know them as the credit bureaus. I call them consumer agencies. I don't give them that type of power. The consumer agencies, Equifax, Experian, and TransUnion, that's what that's for. That's to put them in line and keep them in line. You got those third-party consumer agencies too. You have to use that consumer law. What applies to you? Read the information. Look up the words. You got to look them up in a Black's Law Dictionary or some type of legal dictionary, because those are legalese. And if you don't know the words, just because you might say, you may use in the regular English book one word, it don't mean that in another word in the legal term. So that but let me tell you something. The consumer law, that's your friend, because it protects you. Y-O-U. It protects you as a consumer. And stop being afraid. Stop being afraid. See, is it legal? Is it lawful? Is it ethical? Those are the three questions you want to remain in your mind when you're reviewing a document that a debt collector sends you. Because at the very bottom of this of that document, all documents, ALL, it's going to say, if it's a debt collector, it's going to say this is a debt collector collecting on a debt. Simple as that. They have to do that by law. That's the law. So, but that's what I wanted to say. You know what I'm saying? Look here, I want you to thanks for watching. You know what I'm saying? Stay tuned. I'm gonna have some more videos up for you, and we'll talk to you soon. Stay encouraged.